First off, let's talk about NetLaw. What is NetLaw? For those of you who are not familiar with our company or the history of our company, let me share with you how we began. We started as a law firm, Hargrove Madden, located in Louisville, Kentucky and Lexington, Kentucky. Hargrove Madden is an estate planning law firm. That's all they do, and Hargrove Madden is still in existence today. But as a private practice law firm, I was with the law firm prior to the creation of NetLaw, but as a private practice firm, we were struggling to find a way to more efficiently serve the needs of our clients. Much like you guys have clients all across the country, so did we. Most of our clients come to us through financial services providers. Those professionals refer clients to us for planning, and we were really struggling to find an efficient way to work with those clients, to deliver those legal services, and to communicate and collaborate with the advisors on the planning for that client in a true team spirit manner. So we actually created this technology ourselves as a law firm and really didn't think that we would ever do anything more with it other than use it in our private practice. However, in 2012, the American Bar Association recognized our law firm and awarded us their James Keene Award for Excellence in E-Lawyering. And that is simply the online delivery of legal services. So they took a look at what we were doing on a 50-state model, on a state-specific model, a client confidentiality model, and at least at that time said that we had the best online delivery of legal services of any law firm anywhere in the country, and that's across all disciplines. So we were very excited about that, and that got us to thinking about how can we make this even better? How can we make this a more powerful tool for our advisors that we work with and for the clients that we serve? So we decided to take that intellectual property and move it into a separate non-lawyer company, a technology company now known as NetLaw. So again, NetLaw is not a law firm. It is a technology company. Since NetLaw is, again, not a law firm and we're not lawyers within the NetLaw company, let's talk a little bit more about that. What do you get with the NetLaw plan? This is our premium estate planning package that you all are offering to your clients, and this package retails for $1,000. However, through WFG, your clients get the exclusive pricing of $500 for this package. The package includes a last will and testament, a probate avoidance revocable living trust, and I'll talk about the living trust in a more detailed manner here in a few moments. It also includes financial powers of attorney, your medical powers of attorney, living wills or advance directives, and HIPAA authorization. I want to note that if your client is married, the client's spouse can create the same set of documents at no additional cost, all using one plan. So one plan covers both husband and wife, and it's $500. So let's talk about the fees. We get lots of questions about fees. So I wanted to take the opportunity to go into a little more detail about this. As mentioned, the plan is $500, and that gives your client and the client's spouse full access, unrestricted access to their account for the first 12 months. And what that means is during that first 12 months, they have unlimited changes to those documents. So they can create their documents, and if they are transferred to a new state with their job 2 months later, they can go right back into their account, update their state of residency, and generate new documents specific to their new state at no additional cost. Perhaps that client has a new baby, and they want to add that child to their estate plan. Again, they can go right in, add the child to their documents, create trust for that child, all at no cost to the client. It also includes unlimited document storage and what we call our Life Vault. I'll talk about the Life Vault a bit more as we go along, but that is a secure, encrypted, cloud-based storage, like a safe deposit box in the sky, and they can store all of their documents that they create with NetLaw. Once they're signed, they can scan those signed copies and load them into their vault, along with anything else that they want to keep kind of stored in one place that they can access anywhere, anytime, 24 hours a day with internet access. So what happens after the first 12 months? If your clients want to continue to have the ability to make unlimited changes to their documents, if they want to continue to have the ability to store documents into their cloud vault, unlimited documents, then the fee goes to $8 a month beginning in month 13. Now, I do want to emphasize this is an optional fee. We get lots and lots of questions about the $8 a month. And don't get too hung up on that $8 a month fee. I would really focus on the value that your clients are getting for that $8 a month. And again, it is optional. This is something that the client does not have to continue. They have the ability to actually turn off that automatic renewal from within their account. That's at the client's complete control. So if the client does not want to continue that service, that's no problem. They can certainly let us know or disable that feature within their account. But however, after that 12th month, if they do not continue their account, they no longer have the ability to make changes to their documents or to add new documents to the vault. They will always have access to what is currently in their vault when their account is inactivated, but they just can't add anything new, and they can't make any changes to their estate planning documents. So the next question we typically get is, what happens if, a year later, the client hasn't been paying the $8 a month, but they want to make a change? What happens then? Do they have to pay another $500? And the answer to that question is no. We do have a reinstatement policy that we kind of stair-step for the client. So if it's been within 60 days after their account has gone inactive, they can reinstate that account at no charge at all. There's no cost to do that within the first 60 days. All kinds of things can happen. Their credit card could expire and they forgot to update their account information or what have you. So we don't penalize them if it's been within the first 60 days. From 3 months to 6 months, it is a $79 reinstatement fee. And then if they want to continue the account, they just pick up the $8 a month thereafter to keep their account active. If it's been over 6 months, it is a $250 reinstatement fee. And again, if they want to keep the account active from that point forward, they just start paying the $8 a month that following month. This is something, again, that is completely at the discretion and the option of the client. One of the things or the examples or illustrations I typically give when I'm talking to advisors about this fee, because, again, we get lots of questions and comments about the $8 fee. Sometimes we get questions about, so, my clients are really young. Are they going to have to pay $8 a month for the rest of their life? Well, they can. They certainly can. But I want to put it into perspective for you and for the client. This package that your clients are purchasing through NetLaw that you're offering them, in most law firms, so example, in the law firm of Hargrove Madden where we created this technology, the same package would cost about $3,500. So if your clients are paying $8 a month, it would take them over 30 years to equal $3,500. Actually, it would take them over 35 years to equal that amount. So, kind of put that in perspective for the client. It's really a very useful tool for them. And as their life changes, as they have new babies and grandchildren, or they move, or they retire, or they have a death in the family, all kinds of things, this is going to be a really easy tool for them to update their documents as life happens. So let's talk about that a little bit more. Life events. With NetLaw, we really don't focus on estate planning, the words estate planning. We don't talk about estate planning necessarily or wills and trust. Instead, we talk to clients about life events, things that resonate with clients regardless of who you are, regardless of whether you're married, regardless of how much money you have. These are things that happen within the lives of everyone. It touches everyone. It's just through the process of helping them with these life events. And here are some that we've identified that we talk about at NetLaw, and I'll go into some of those in detail as we go forward. But clearly a change in marital status is a need to update your estate planning documents. If it's a marriage, a divorce, or even a death in the family, that's going to be an opportunity for you to sit down with that client, help them review their beneficiary designations, help them with the NetLaw plan to get that in place so that their estate planning coordinates with their beneficiary designations as their life events have occurred. I've talked about, the birth or adoption of a child. You really need to encourage your clients to update their documents to include that child in their last will and testament and their trust. if they move to a new state, every state has their own very specific laws with regard to estate planning, and in particular, the health care documents. Those are very, very state specific. So if your clients are moving to or from a different state, you want to make sure that they're aware of those changes and the need to update their documents. So let's just move forward a little bit more. Why is estate planning important? Let's talk about wills. Everyone seems to have the impression that they don't need a will because they're not wealthy, or they're married, so their spouse is going to get everything anyway, so, why create a will? Or they've already told their friends and family members what they want them to have upon their death, and everybody knows, so there's no reason to create a will. Well, that's absolutely wrong. That is very inaccurate, and your clients are putting themselves and their families at risk. One of the things that I tell clients is, if you do not have a will, your state has one for you, and it is called intestacy law. Every state has that. And basically, the law states what happens when you die without a will, who gets your assets, and it is according to state law, and more than likely, it's not going to be the way your clients intended their assets to be passed. So it's very, very important that if they feel strongly about who gets certain pieces of their assets upon their death, they really need to set those out in a last will and testament. Another reason to create a will is if your clients have minor children that are under the age of 18, because this is the legal document that is recognized by courts where your clients will name a guardian for that child. Without naming a guardian in their will, they're really putting the future of that child at risk. They're not letting anyone know who they want to take care of that child. And a judge doesn't know. And guess what? It's going to be a judge that makes that decision. So oftentimes you have family members fighting over the custody of that child. And, you've got husband's side of the family fighting, saying that, no, my son wanted me to have her. And then the wife's side of the family saying, no, my daughter wanted me to have her. And the judge doesn't know. So it's super easy to avoid that entire situation just by naming a guardian in your last will and testament. In some of the most extreme cases, these children can even be placed in foster care until the guardianship can be worked out with the courts. And that's something that nobody even wants to think about or have to go through. So encourage your clients to make sure that they have that in place, especially if they have minor children. So let's talk about avoiding probate. I mentioned when we were going over what's included in the NetLaw package that our package includes a probate avoidance revocable living trust. And that is exactly what it says, exactly what it means. This is a trust for the purpose of avoiding probate. In some states, probate can be very, very burdensome. It can be very time-consuming and very costly. Some states have statutory probate fees that are based on a percentage of the assets held within the estate. So this is a way that you can help your clients save money, save time, and save the burden on their family of having to go through this process. I also want to mention that probate is a public process. It is the court-supervised process of administering the estate, distributing assets, paying final debts and expenses. And the reason I say this is public is because anyone can go down to the courthouse and pull your client's estate file and look at everything in the file. They can look at all of the assets that the client owned, what they're valued at, and how they're being distributed and to who. For those clients that are very private in nature, or maybe they live in small communities, or they just don't want to take the risk of having their nosy neighbors or people they go to church with, or their ex-husbands or ex-wives or in-laws having the ability to go down and pull their file and see everything that they have and what it's valued at and where it's going, this is a good way to keep that information private. By using a probate avoidance revocable living trust and taking your individually owned assets and retitling them into the name of your trust during your lifetime, those assets are not subject to probate, and they pass automatically according to the terms of the trust. So again, the trust is private, that is kept private, whereas the probate process is not. It's a very public process. This is also a great way to maybe help older clients plan for disability. If you have your assets already titled in the name of your trust and your client becomes incapacitated or disabled for whatever reason in the future, The family members do not have to go to guardianship court and be appointed as guardian to then take care of the finances for that client. The successor trustee is already named within the trust, and they can step right into the shoes and start paying bills and making distributions and carrying on for that client just as they would for themselves. So this is a wonderful, wonderful tool for your clients, and it is part of the NetLaw package. Medical decisions. The healthcare power of attorney, in some states it's referred to as a healthcare surrogate. In some states it's combined with other provisions for advanced directives. These are very state specific, so however these documents are referred to in your state is how they will be created when your client goes through the NetLaw process. But the medical power of attorney is the document that a client would name someone to make medical decisions for the client if the client could not do so for himself or herself. So this is a situation where your client cannot speak or communicate for themselves for whatever reason, and they need someone to consent to treatment or to move them to a better facility for more specialized care. Those types of decisions are the decisions that are controlled by the medical power of attorney. I always tell clients that I can guarantee that most people know who they would want to make medical decisions for them if they couldn't do so. And if you can't think of that person right off the top of your head, I'm pretty sure you can think of who you would not want to make those decisions for you if you couldn't make them for yourself, and that usually gets their attention. So make sure that your clients know that if that's important for someone that they love and that they trust to make decisions for them, if they're not able to do so, they need to make that known in a medical power of attorney. Because again, without that, a judge is making that decision. And a judge doesn't know that you don't want your brother making those healthcare decisions and that instead you want it to be your sister or your mother. So make sure that those decisions are known. So let's talk a little bit more about what your clients get. We do have a network of estate planning attorneys and elder law attorneys that are available to assist your clients if they need extra help. Now, keep in mind that your clients can complete every single one of these documents entirely on their own without the assistance of a lawyer. If they have an unusual situation, maybe they have a special needs child, or they're a business owner and they need to talk about more advanced business succession planning, or perhaps they're very wealthy and they need to talk about tax planning, they can connect with one of our network attorneys for that additional assistance and services. If they do so, there is a fee that is charged, and that fee is at the discretion of the attorney that they connect with. We cannot control or dictate the fees that our attorneys charge clients. What we can do is make sure that they are available for the client if they need additional services. So keep in mind, if your clients need that extra help, they can connect with an attorney through our network, but there is a separate fee for that that goes straight to the lawyer. That does not come back to NetLaw, and you can. So let's talk a little bit about the Life Vault. We mentioned that earlier, and that is that secure encrypted environment where your clients can store all of their estate planning documents. So once their documents have been properly signed, they can scan those signed copies and store them in their Life Vault along with tax returns and deeds and insurance policies and birth certificates, marriage licenses, passports, anything that they want to keep in one safe place that they can access anywhere with internet access. This is a great tool for the advisor as well. This is really a fact-finding tool for you guys, and this is how that works. And some of the advisors that we've worked with, what they're doing is they're offering to help the client scan these documents and place them in the vault. So if you've sold the NetLaw plan and you have an office where you've got a notary and some people available to witness documents, you might offer that the client come and meet with you in the office and help them get those documents signed, and then offer to scan them and put them in the vault for the client. And while the client's there, you might encourage them to bring in anything else that they may want to store in their vault, like their life insurance policies and their brokerage statements and their IRA statements and the deeds to their home and their tax returns and anything like that. Because then what you have is the client coming to you with a box of very valuable information, and you're helping them. You're just providing a service. You're helping them to get that information into their vault. It is a $500 plan, as mentioned, and we let them either pay that all at one time, or they can finance that over 12 months if they want to at $50 a month. we do give one last option for the client. So if they are hesitant for whatever reason, maybe they need to talk to their husband or their wife about this first, or they weren't really expecting this expense at this time, or for whatever reason,